Hi, and welcome to another episode of Ask on CYC. So as Christians, it's easy for us to commit sins. It is also easy for us to commit crimes in our society. However, as Christ is lenient with us and gives us second, third, and a million chances, our legal system is not as lenient with us. So it's up to us to be careful and also to understand our rights as citizens, because we are always will be innocent until we are proven guilty. So we have with us tonight a defense attorney who will give us his insight on this line of work and give you advice. So please, if you have any questions, send your questions to 0416 551 292. Let me introduce you to tonight's guest. We have with us Michael Moussa.
Thank you, mate. It's good to be here.
Welcome to the show.
Thank you.
It's a pleasure. So you're a defense lawyer.
I am, yes.
Okay, so what's that mean?
Well, a defence lawyer is a person who protects the rights of the accused, or the alleged accused for that matter, ensuring that the prosecution does its role correctly. And the word defence doesn't always come into play. There are circumstances where people may just have done something wrong and plead guilty to that offence. So the word defence there wouldn't necessarily apply because you're not defending anything per se. You're just basically making submissions to the court on behalf of the person who's found guilty or has pled guilty to the offence.
So how long have you been a defence lawyer for?
I've been a defence lawyer for a little bit under 4 years now. It is my preferred type of law to deal with. Yes.
Okay, and what school did you graduate from?
To become a practicing lawyer, there are a few things, a few schools that you have to go through, as you probably would understand.
Sure.
Very similar to the medical field. So your Bachelor of Laws, I actually graduated from the University of Western Sydney. I also completed what we refer to as the practical component, which is the Graduate Diploma in Legal Practice. And also just recently I've completed my Masters in Laws, Criminal Prosecutions.
Okay, congratulations.
Yes. Thank you, thank you.
Okay, so we just wanted to get familiar with you. That's why I'm asking you all these follow-up questions. So
sure.
Did you always want to become a defence lawyer?
I think probably from about first year of university, having done subjects revolving around the criminal law, particularly around evidence, I came to understand that it is a law that I really like. Justice for the individual was something that I always took a fond nature of, and as a result of that, I basically pursued that objective, and here I am.
Okay. Just a reminder to our viewers, please, if you're thinking about becoming a defence lawyer, you're starting down that path, and you have any questions that you want to ask Michael on tonight's show, the phone number is 0416 551 292. Please send us a text or give us a call and speak to Michael tonight on tonight's show to get your questions answered. So as a defence lawyer, Michael, how often do you appear in court?
I'd say daily, through the different courts. There are a few courts in New South Wales. The local court, the district court, the Supreme Court, sometimes even the High Court, very rarely though. So I'd say daily, yes. Okay,
and in the criminal court, who are the key players? So let's give an audience an understanding on the system and how it works.
Okay, it's important to understand which court you're in first of all. In a local court, and I'll just start off with that, you have the magistrate, or others refer to him as judge, but his proper name in the local court is the magistrate. He is the person that determines the accused guilty or innocent. And he has regard to the evidence that is led by the other key player, which is considered my opponent. They're referred to as police prosecutors in the local court. And then you have the defence lawyer, which is myself or anyone who's representing the accused in those circumstances. Now in the higher courts, so the district court, for example, you've then got the judge, not the magistrate. Now, the role of the judge in the district court is different to the role of the magistrate in the local court, depending on whether there's a jury or not. So they're generally the key players. So the added party to those three that I've mentioned is the jury, and usually find them in more serious cases in the district court or above, so the Supreme Court. So for example, a case of murder can only be found and heard in the Supreme Court.
Okay, so in more serious cases where the jury is involved,
Yes.
they have the say in whether they're guilty or not the judge.
So the term given to the jury in the district court is that they're referred to as the judges of fact. The judge in the district court, his sole role is to determine, he's the judge of the law. So in a trial you have a lot of things that arise. Should this evidence go in? Should this not? Is it relevant? Is it not? And in the absence of the jury, so the judge will ask the jury to leave in those circumstances, and then it will just be a battle between the prosecution, which in that case will be the DPP, which refer to as the representatives of the Director of the Public Prosecutions. They're the people that basically we battle it out, and the judge then determines whether that evidence should or should not go in. But the jury is just to determine one thing and one thing only, the judge of fact, in order to determine whether the accused is guilty or not guilty in those circumstances.
Okay, but in a smaller courts where it's just the judge, he makes the final ruling.
The magistrate makes the final ruling, and there are also judge-alone matters that don't necessarily need juries in those circumstances, and yes, they determine the guilt or the innocence of the accused based on the evidence before them.
Okay, and just to what is your role as a defence lawyer in these court systems?
Okay, so my role, I have a few roles actually. The main roles are first ensuring that the prosecution or the DPP does what they need to do. And let's face it, a lot of the times they get it wrong. They do things that they shouldn't have done. They led evidence that they shouldn't have led. My role is to determine what evidence should be going in, whether they have a case to answer. My role is to also represent the interests of the accused in those circumstances to ensure that he gets a fair trial, and to lead any evidence that's inconsistent with the evidence that's provided by the prosecution or the DPP.
Okay. So moving on to my next question, what is plea bargaining?
Okay. Plea bargaining it's got a number of terms. So it's referred to as plea bargaining, plea negotiations, representations. Some solicitors even shorten it and call it reps. But basically that's written communication, or it could be oral communication, just depends on the circumstances, that basically request the prosecution or the DPP to do one of three things. One, to withdraw the charge in circumstances where each element has not been satisfied. So it's persuading the prosecution that this case is not a good case to run, and therefore in the interest of justice and in the interest of saving the court time and resources, you should exclude the charge outright. And to give you an example of that, say for example in a sexual assault case where one person is saying consent, one person is saying there was no consent, and there's no other evidence led by the prosecution in that case there. It would be a case of his against her word, and therefore it would be appropriate in those circumstances to write to the prosecution or to the DPP to say, look, we're going to have this problem in the trial, let's not waste the court's time, and just refuse. They then have the discretion to say yes or no. The other reason that plea negotiations are used is, say for example, you've committed 2 offences in the one night or in the one day. You would, considering the circumstances of course, you would write to the prosecution, if it is valid, to perhaps withdraw one and then give them the guilty plea for the other one. And some people would accept that. And the other one is very simply rebutting any evidence that they may have in order so that matters can sort of be negotiated outside of trial.
Okay, but how often would you recommend or would you prefer to plea negotiate?
I think, Mina, it's very important, just like any big matter, to avoid court. And it's the same in criminal matters. If you can save your client a lot of money, and if you can save the court's time and enter into negotiations with the prosecution or the DPP, I think that would certainly be a favourable outcome, certainly for the client. So it's very hard to determine a time, but it's just by case scenario. But we do prefer to try and negotiate it outside of litigation or a trial in that matter.
Okay. We actually just got a question that's come in from an audience member.
Yes.
They're asking, what does a criminal lawyer do when their client is guilty?
Okay.
How does that play morally, and do you defend them?
It's funny because I was thinking about the questions that might be asked, and this was the very first question that I get asked all the time. And thank you for asking that question. Before I do answer that question, though, it's important to understand that Australia is bound by Constitution. And the very first point is this, that everybody's entitled to a legal representation, guilty or otherwise. So once we've satisfied the knowledge of that, we now go into step number 2, and that is this, that instilled in the Constitution are these principles that have been enshrined since the olden days. One of those is what we refer to as the Presumption Innocence. And Mina, you were wise enough to introduce this in your introduction, where you said that every person is treated innocent until proven guilty. And that is a very important principle. There are a lot of things that people do not know or see that, for example, somebody like the defence lawyer would see. And I'll give you a classic example. If I told you that this person has been charged with murder, he hit somebody, say, at a bar, and the other guy got hit his head, fell down, and sadly, he passed away. You would think that guy is not good and psycho and he should be sent to jail, and how can you represent that person? But if I then added just one fact and said to you that before the other person hit him, he had a knife. So he was provoked by a knife. Would that change the circumstances? Would that change the perception on what has occurred? Certainly. So I think it's important to give everybody a fair go. If I know that the client is guilty and the client wants to be defended, I would advise against that. I would say that look, my job is to protect your interest consistent with the law, and I would write a letter of advice to him, ensuring that it is in a letter of advice saying that you've advised A, B, C and D. Based on what you've advised, there are no defences, and therefore you should plead guilty. Now, if he decides to plead not guilty in those circumstances, the law permits me to still represent him. However, I have 2 rules that I must satisfy. One is important and one is very, very, very important. The important one is that I'm bound by my instructions. What I mean by that is that a person who says to me that I want to plead guilty, I must follow that. If a person says to me, I want to plead not guilty, I must follow that, obviously subject to my advice. But the more important, and we call this the overarching rule, is that you have a duty to the court. You can never mislead the court. And sometimes ethical dilemmas do arise from that. So I hope that answers your question.
Okay, so let's move on to the second part of it, about the moral dilemma.
Yes.
So the audience member is asking, how does that play morally with you when you defend them?
It would be very rare that a person would come into my office and say to me, listen, mate, I've done the offence, please try and get me out of it. It's very rare. There's always things that arise. And that can range anywhere from a mental illness to other factors such as self-defense, or other factors such as the person's going through a bad time in their life. I'll give you a classic example. I had a client come to me the other day and said to me, "Look, I've just been caught drink driving." That person then, the very first thing that I asked for was a copy of his traffic record, and the traffic record was clean, and this person was approximately 50 years of age. So certainly, and I said, "What's happened? I mean, you've been driving well for 50 years. What's happened?" And what was said to me was quite interesting. What was said to me was, I just recently came out of a separation, and I'm not going through, the best of times. Drinking for me at this point is a way of, releasing my tensions. So in those circumstances, I think that person should plead guilty, and the magistrate of the local court should take that into consideration. But ethical dilemmas generally arise in circumstances where the client wants me to mislead the court, at which point I cannot. That's an overarching rule that we can never do. In fact, a lot of people have been disbarred from becoming a solicitor in circumstances where they have misled the court. So it's important that solicitors do not do that.
Okay.
Yeah.
I know you mentioned this earlier, but I just want to confirm it. So if a client came up to you and said, "I am guilty, but I want you to, get me a non-guilty plea."
Yep.
Under their instructions and through your advice, you would go ahead with this?
So what would happen is that I'd first find out why he'd want me to plead not guilty, and if he just said, whatever, I just want you to get me out of it because I'd say to that person, look, my role is to be bound by your instructions, yes, but I highly advise that you should not do this. And I'd actually send him a letter advising that, this is what you've advised me, and I'd take file notes of everything. At times I'll even get another solicitor inside to ensure that, everybody's on the same page.
Have you turned anyone down?
Yes, we
Oh,
have.
really?
We have turned a
Yeah.
number of people down, and usually those circumstances are where client wants us to do something that goes against our moral beliefs, or against something that's enshrined, say, in the solicitor rules. Solicitors are bound by what we refer to as the solicitor rules, where I've got all those. Remember how I said the overarching rules? They're all found from the solicitor rules. And when people want us to go against that, then we generally say, look, go find somebody else. We're not the team for you.
Yeah. All right, we've got time for one more question, then
Sure.
we'll go for a quick break.
Sure.
So this is actually a question that came in from an audience member. They're asking, have any of your clients threatened you, and how have you responded?
I think probably in the number of years that I've been a defence lawyer, I think I've probably only ever had one issue, and that was through an email. One person has probably threatened me through an email. And generally the course taken from that is you just ignore them. It may have been that they were expecting an outcome that they didn't get, or it may have been that, there's a lot of sensitivity in criminal factors, and rightly so. I mean, you go through a daunting experience, and often that could lead to stress. And he kept on going and going and going, and I think what I did at that point was I spoke to the other solicitor that I work with, and what was appropriate in those circumstances was to contact the police and get an AVO against him.
Oh, wow.
Yes.
So that's serious?
Yes.
Yeah.
Yes.
Okay. We're going to go for a quick break,
Sure.
and we'll come back and we'll continue our discussion.
Okay, great.
Thank you to our audience members for tuning in. And please, if you have any questions, don't be shy. This is one in a lifetime opportunity to ask a defence lawyer a question. The number is 0416 551 292. Send us a text or give us a call and speak to Michael on tonight's show. Thank you.
CYC, Christian Youth Channel.
Hi, and welcome to Ask on CYC. On tonight's topic, we have with us a defence lawyer. So please, if you have any questions, send your questions to 0416 551 292 and ask our defence lawyer on tonight's show. So getting back into it, we actually got a couple of questions that just came in while we were on break. One of the audience members is asking, I was assaulted and the police arrested the man. He was taken to court, but I never found the result. How can I find the result of a police prosecution?
So as a victim, you would have had some communication either with the prosecution's branch or with the OIC. The OIC refers to as the officer in charge. So they would have contacted you. There is no harm in you contacting them by finding out which police station they're at and saying, look, you know, I was a victim in this matter. Do you mind advising me what the outcome of that case was? And they should be able to give you that information unless it's still on foot. If it is still on foot, then obviously they probably will refrain from giving any information simply because a verdict has not been made in those circumstances.
Okay, so I got a question on this. So why wasn't he asked to come to court to be a witness for the prosecution?
Yeah. Well, a number of factors. The first thing could have been that person decided to plead guilty. So witnesses are only required if it's contested, if a person goes in with a not guilty plea. When a person goes in with a guilty plea and pleads guilty to the offence, that means that they concede, they did it, they want the court now to take into consideration A, B, C and D, and the matter is generally dealt with straight away on that day. So it may have been the case that in your circumstances, sorry, you're asking the question. It may have been the case that in those circumstances that person has pled guilty. Another factor, it could have been because of public safety. It could have been one of those very serious cases of, say, domestic violence. And I don't know too much about the offence, but certainly in domestic violence cases, where, say, a husband and wife have been married for a long time, it's usually prevalent that they usually try and stay away from each other, subject to the fact that they have a statement, and that statement is adequate to the court or to the prosecution in this case, and that would determine whether or not the victim is required to attend on those circumstances.
Okay, that's very interesting. Yeah. So another question that came in from the audience member, they're asking, this is an interesting question, and what is it like being a Christian and a defence lawyer?
Mm-hmm. That's a hard question. I think it's important to understand a few things being a Christian. The fundamental principle of being a Christian is to understand that we only have one divine judge. That person is the person who judges you for your problems, and it'll be wrong on me, whether it be in my Christian capacity or as a defence lawyer, to judge anybody that walks into my office, or any party for that matter. So the important thing is that what I generally like to do is leave the judgment, the legal judgment for the judge, and the divine judgment for God. I don't draw any inferences when people speak to me, and I don't draw any judgments. Certainly from time to time it will be very hard for you not to draw inferences, but as long as they stay at inferences and they don't sort of go into judgment. Also, as a Christian defence lawyer, it's important that I'm transparent. If people want me to do something that may be considered inconsistent with the provisions of my obligations, it's important that I'm forefront and honest with those requirements. I hope that answers your question.
Yeah. We actually got a question which involves a Christian dilemma.
Yes.
There's audience members asking, do criminal lawyers need to lie in some circumstances? Would you be able to provide an example? Sorry.
I would have to say no. We generally try not to lie. One, it's unprofessional, unethical. There is a very fine line between lying and the art of persuasion. The art of persuasion is what defence lawyers do in order to determine mitigating, that's what we refer to as mitigating factors. So for example, a person has been charged with say a driving offence, right? And that person was feeling a little bit sick on his journey, all right? There is no harm in me saying to that person, can you please go to a doctor to get assessed to see whether on that day you were sick, or did you see any doctors, perhaps the following day or something. And if that doctor is happy to write you a report, then we can use that in mitigating factors. If the doctor is not happy to write, having assessed you, then we can determine other tactics in order to see whether we can assist him or her. Whether that constitutes lying or not, I would submit no. I would say that it's just a forensic decision in order to assist your client in mitigating factors.
Okay.
Yes.
So moving on to the whole legal terminology and legal aspect of it.
Yes.
So how can the prosecution's evidence be rebutted? So if you're sitting there defending someone and
Yes.
the prosecution throws an evidence at you, how
Yes.
can you?
Okay. So generally in a hearing or a trial, what happens is that the prosecution gives their evidence first. So that could be by way of document or it could be by way of a witness. Okay. Assuming the prosecution calls a witness, okay, we can rebut that witness by a term referred to as cross-examination. Cross-examination, for your viewers, is basically asking a series of questions to lead to a certain inference or a point. So for example, if the prosecution is alleging that the car was red, but my client has told me that the car was black, I'd be cross-examining about the car, saying, well, was the car red or black? And I'd be getting answers, because whatever comes out of that person's mouth as a witness is considered evidence, which is much more, it's much more weight than what I would say to the court as a defence lawyer. Because what I say to His Honour is referred to as a submission, it's not evidence. Whereas what a witness says is considered evidence. So that's one way. And the other way, obviously, is the obvious way, and that is to find evidence that is inconsistent with the evidence that they're proposing. So, for example, if somebody's saying that this person is unlicensed, and I can find a receipt, say from the RMS to say that he went and got his license renewed on this day, then I would submit that as evidence to be inconsistent with the prosecution's evidence. So they're the ways that you can rebut the prosecution's evidence.
Sure. Okay, so hypothetically, say I'm guilty.
Yes.
And I come to you and I say I'm guilty. So what's the next step after that? What do you do for me?
So you've come in, you've pled guilty. I will have a conference with you. I'll ask you a series of questions. What happened? Let me know what happened. I'll try and get a series of events. And what I'm looking out for is, you might think you're guilty, but really you're not guilty. So I'm looking out for things that could be used as an argument to defend your matter. If after I've assessed the circumstances and I realise that, okay, there are no adequate defences that would stand in court, we then would proceed to the court on a guilty plea. And usually what happens then is that we ask you to get us a couple of character references or things that would assist you in mitigation. So in drink driving matters, we'll ask you to attend what we refer to as the Traffic Offenders Program, which is a program solely used for people with driving issues, a form of counselling, which is done by way of presentation, and it's usually around 1 day. So we'll ask you to undergo those programs. And then the matter generally is dealt with at the time. So the judge or the magistrate will sentence you at that time, taking into consideration all the factors. To give you a classic example, I was driving and I was caught doing 30 over. As you're aware, 30 over is a mandatory 3-month suspension, so you lose your licence 3 months on the spot. But I'm a traffic driver. I withdraw that. I'm a truck driver, and I need to drive trucks for my living. This would be a great example of getting a letter from your employer to say that you need your license at that time. We will then proceed with a guilty plea and then submit that to the court. The good thing about going in with a guilty plea at the very first available option, it has its benefits. And that benefit is very simply that you get what we refer to as the 25% discount. Yeah.
Yeah, so you get a lesser sentence.
You get a lesser sentence.
Oh,
yeah.
okay.
Yeah.
So if a person knows that they're guilty, it's better not to fight it if they can get a 25% discount.
Well, absolutely. Absolutely, yes.
Sure. All right. So I got a question that just came in from the audience.
Yes.
They're actually given us a scenario. You view all the evidence and determine that the client is guilty, but they don't admit to it. What do you do, and do you make judgments on whether they are guilty or not?
I'm going to have to ask you to read that question again,
sure.
if that's okay.
So they're saying the scenario is you view all the evidence and determine the client is guilty, but they don't admit to it. What do you do? And do you make judgments on whether they are guilty or not?
Yeah. Well, I can answer the second part of that question very simply. I don't make any judgments in respect of matters. My job is to ensure that my client's rights are protected. And now again, sometimes it's very hard to draw inferences. Sometimes things just don't add up in my mind, and sometimes it absolutely makes me go crazy because, you know, your client may have said something one day and then they changed their story the following day and they changed the following. But I don't draw any judgments. I sometimes take an investigation role, which I shouldn't, but sometimes I do. And I think that's okay. Answering the first part of that question, what I will say to that is that very simply that if I've assessed all the evidence and I think that the client is guilty of the offence, but they're still persisting with a not guilty plea, I would give my advice and I'd make sure that it's in written form. And then after that, I'll basically get signed instructions from what they want to do. If they want to plead not guilty, then I'd ask them to sign instructions that they plead not guilty, constantly reminding them that it's in their interest not to plead not guilty. And in circumstance, depending on the case, I might withdraw myself if I feel that I'm going to run into an ethical dilemma. Or if I'm going to run the case, I need to make it abundantly clear that I will not be saying anything or doing anything to the court that will be inconsistent with what they're submitting, what the Crown is submitting. So for example, I'll give you a classic example, just put things into perspective. If my client has said, no, I didn't hit him, and then after that, later on, he comes to me and says, at the 11th hour, by the way, I did hit him, but I still want to run the case, and I've only got one day before the trial, it will be very unfair on me to say to him, go find another legal team one day before his trial. So what I would say in those circumstances, that's fine, but if you choose, for example, to give evidence, as you're probably aware, Mina, you're not forced. The defence has a right of right to silence, so they don't have to say anything. But if you choose that you're going to give evidence, I'm sorry, I'm going to have to withdraw myself from this matter. But if you are not going to give evidence, I can still run this matter. So it's just sort of playing it tactic from that perspective.
Okay,
Yeah.
Very interesting. So I'm a big fan of legal TV shows like Boston Legal and Suits.
So am I.
Yeah. And it's very exciting and it's very fast paced. But do they really portray what being a defense lawyer really is, or is it just hyped up Hollywood dramatic TV shows?
Well, perhaps we should invite Harvey Specter into your show. Look, without getting into too much information about the differences between Australian law and American law, I'd have to say that the second you walk into a trial, I'd say that we're very similar. I think the differences occur before the trial. So what that basically means is that you may have heard of terms such as a grand jury. In America, they have what we refer to as a grand jury, and that's basically where you have citizens of anywhere between 16 to 24 citizens picked randomly, And their role is to determine, right, and they have a lot of influence. Their role is to determine whether that person should be accused or not. Otherwise, in other words, sent on indictment. In other words, again, sent to a trial. They determine whether this person goes to trial or not. In this case here, there's only one institution that determines whether a person goes into trial. And that's a combination of New South Wales Police and a not guilty plea, or the DPP and a not guilty plea. There's no grand jury, for example. So that's one of the differences that you'd find between the American laws and the Australian laws. However, once you walk into the trial, it's the same thing. Prosecution gives their evidence, defence then gives their evidence, jury makes a decision, or judge makes a decision. And as they say, Bob's your uncle.
Yeah. Listen, I want to talk about a recent case that's made Australia go crazy, and please feel free, to answer it to your certain extent.
Yes.
And if you don't want to answer, you don't have to answer.
Yes.
But the recent case about the manslaughter case of the guy who came into his daughter's bedroom
Yes.
and found a man standing over his daughter's bed, and he defended his home, and resulted to this man being, passing away. So now the Australian law is calling it manslaughter, but the Australian public is saying, no, this man has the right to be innocent. He's not guilty. So what's your opinion on this?
I mean, there are a lot of those cases, where, the thief comes in and you hit him just a bit too hard and the person dies, and, the person looking bad is the person that hit rather than the thief. What I will say to that is this. Well, first of all, every life is valuable, okay? So once you start dealing with extremities such as death, the law needs to do something. The parliament needs to do something. The judges and the judiciary need to do something. And whether that's going to be successful or not as a catalyst to any future events of this nature would be open to interpretation. What I will say is this: that person who has hit and subsequently caused death in circumstances where a robber was inside their house would have a very valid defence. Okay, and unless there was persuasion in that thief coming in or anything of that nature, there would be a very good defence. And I think that would certainly be attributable to the sentence that any person provides in the future.
Okay.
Yeah.
I've got one final question for you before we end the show. And this is, any advice or any words of wisdom that you want to give to someone who's studying law, who wants to study law, and who wants to follow down the path of being a defence lawyer?
When I ask advice from my senior mentors, the way that I like to appreciate the advice is by looking at the pros and the cons of a certain issue. And I'll do the same on this occasion, because I think it might be interesting to those who are there. The pros of being a defence lawyer, as you probably would understand, is that it's rewarding, not only from a financial perspective, but also from a mental stimulation perspective. You're always mentally stimulated. Did he do this? Didn't? You're always questioning things. You're always assessing things. So to me, that's a pro. The other pro is that you get to actually serve the community. There are a lot of low social economical people that don't have rights and don't have the resources to receive legal representations, particularly in the Indigenous community. So to some degree, I'm serving the community. The other pro is that you get to see a diverse range of people. You see the mentally ill all the way to the blue collar crimes. You get to see how people think, and you learn a lot from your clients. The cons, as you'd probably, apart from the ethical dilemmas that we've looked at today, The cons are sometimes you're doing 16-hour shifts. Sometimes I receive calls at 1 o'clock or 2 o'clock in the morning, person's at a police station and, they need some assistance and guidance. I certainly like my sleep, so that to me is a con. Other cons would be things that it's an industry that's highly competitive. There are a lot of defence lawyers out there, and a lot of good ones for that matter. And once you go then from the threshold of the defence lawyers, you then go into the second category of counsel or barristers. And there are a lot of really good defence barristers. But what I will say in general, if you're a university student considering law, enjoy what it is that you're doing. If you feel that you enjoy reading cases and understanding things and you're very analytical, I think it certainly will be a suitable career for yourself. Speak to the senior lawyers that have had a lot of experience in it and find a niche that would be more suited to you.
Sure. Yep. Okay, I'd like to thank you very much.
Thank you.
And in my professional opinion, I think you're guilty of giving us a very insightful show tonight.
Thank you.
Thank you for having me on the show.
It's been a pleasure. Thank you.
And thank you to our viewers for tuning into tonight's show. I'm Amin Ibrahim from your CYC studios in Sydney. Good night and God bless.
CYC Christian Youth Channel.